there are so many issues that are wrong with this particular bill on multiple fronts. But I think I would start with the very foundation of our political system and in terms of the Westminster system and Western democracy and in the concept of the separation of power. Mr. Speaker, we have that for a reason. We have checks and balances between the legislature, the judiciary, and the executive for a reason. We have, Mr. Speaker, the principle of comity that the Honorable Shane Jones likes to talk about a lot in this House for a reason. But this bill fundamentally goes against all of that. This bill is an overstep of the executive power into the judiciary. And a number of experts have identified that in their submission. The New Zealand Bar Association, the New Zealand Law Society, and let's see, the South Auckland Bar Association. So these are people who are experts in the field of legality and judiciary. And all of their submissions unanimously said that we oppose this bill. Why? Because from the judiciary perspective, who have to put up with the consequences of this bill, it was awful for them. It was terrible for them to have to manage it the first time round. You know, in one of the submissions, in terms of what the judiciary said, they said that when it comes to providing deterrent in the case, or in the talking about the three-strike law in the case of Crown and Campbell, the court commented, it may seem very surprising that this consequence could be required by law for an offense of this kind, but that is the law, and I have no option but to enforce it. That is an overreach, Mr. Speaker. That is not conforming and not respecting the principle of comity. But that's not the only issue we have with this particular bill. We have seen it in case law over and over again in terms of the violation that this legislation, the first time round, have on our fundamental Bill of Rights in Aotearoa. In the first time round, we see numerous instances of the violation of Section 9 of ORA, which is the right against torture and cruel treatment. Sorry, right not to be subjected to torture and cruel treatment. And that was particularly evident in the Supreme Court's ruling in the 2021 case of Crown and Fitzgerald. But that was not all, Mr. Speaker. We have said that when we received the department report, when this bill first came to Select Committee, the departmental report said that, well, you know what, at least it's not retrospective. Well, guess what? The Select Committee, despite the advice from the official, despite the advice from the public, despite advice from some members on that Select Committee, decided to introduce retrospectivity, which again is fundamentally against Section 26 of the Bill of Rights. This is no small matter. We have seen this government violating the Bill of Rights, our fundamental document, one of the fundamental documents in Aotearoa, New Zealand, over and over again. Some may say, look, this bill is different. This bill has changed. We've introduced some safety valves that potentially will manage it, but not in the cases, some of the cases I have just listed. In the case of Crown and Fitzgerald, Mr. Speaker, that if you're looking at Schedule 2 of this bill, Section 135 on indecent assault, in terms of whether it's severe or not, is still one of the 42 qualifying offenses, which is what got the Fitzgerald and Crown case the way that it is in the first place. But, Mr. Speaker, that is from the perspective of legality. That is from the perspective of theory. Maybe some people are like, well, what's the big deal? What are we going to see in our communities? Not a lot. Not a lot as a result of this bill. This is not going to be helpful. You know, in many of the submissions we have seen from lawyers, from experts, from community leaders, they said this bill will not help in terms of driving down crime. Even the statistical modeling that we've seen from the previous sessions suggests that this provides no significant deterrent for reoffending crime. But what we will see, Mr. Speaker, is that we will see an increased number of prisoners in our prisons. Well, you know what, to the Honourable Minister, it's not so much about increasing, well, they can't commit crime, you're right, but you're kicking the can down the road. But you know what else is the problem here? We have seen the previous time that introduced it, take a call and use your full 10 minutes, use your full 10 minutes, government members, but the last time this was introduced, at stage 1, 63% of offenders were Māori. At stage 2, 82% of offenders were Māori. And at stage 3 level, 81% of offenders were Māori. And this government wonders why we say prison is the only housing policy they have for Māori. This is not the only issue though, Mr. Speaker. Increasing the number of prisoners is only one part. We're also going to see a backlog in the courts. If you're going through the bill, and as we go on to the committee stage, we have a number of amendments on this bill because the back and forth that the court will have to do to determine various levels of warning and various levels of appeal is convoluted, to say the least. So what is the support to our already struggling court system? Yes, there is a bill currently going through the House on increasing our district court judge by 1. But Mr. Speaker, that is not going to add any help to the staff and to the people who are currently working in the court system. It's not going to add any help to the already struggling legal aid system that we have in Aotearoa. So in fact, we are actually going to see more people potentially on remand as a result as well. But Mr. Speaker, another point that we're seeing in terms of the community, and I will talk about other submitters as well, but I want to first speak from the perspective of the offender. The Green Party of Aotearoa believe that the best form of rehabilitation is if we have a restorative justice system, where those who do offend, our prison founder, feel like that the society still want them to be a part of it. This bill, Mr. Speaker, does nothing to address that. What is going to happen to an offender, Minister of Mental Health, when we are seeing that they have a sense of neglect? when they feel let down by society, when they feel like, you know what, the society is against me anyway. Screw it. I'll just do whatever. I don't really mind. That's not how we reintegrate people into our communities, Mr. Speaker. But finally, we also heard submissions from those who have been victims of this. And crime is never okay. And we are always going to be speaking for our victims. However, but when we ask them, if this bill, how do they know by evidence that this bill is going to help drive down the crime? What evidence do they have of that, other than maybe make them feel like crime is going down? There was no response. Because this is not the way to do it, Mr. Speaker. So finally, the Green Party will not be supporting this bill. This bill fundamentally undermines the constitutional arrangement of Aotearoa New Zealand. It also does not provide any form of safety for both the victims and offenders. And we will be gladly debating a lot of these in the committee stage to come.
James Nigger.
Thank you, Mr. Chair.
Okay, so that's Lawrence's speech there.
I
think it's really interesting. Oh, go ahead, Alex.
I'd like to say I think Lawrence has some pretty good points about the bill not working. But the problem is that, say, the three strike law, it doesn't stop a vicious cycle of reoffending, to be honest, if you know what I'm saying.
No, it doesn't. It just basically keeps things going. Plus, it also doesn't actually put the checks and balances in place that actually stop the reoffending. Like parole, like rehabilitation courses. Yeah. Should we get to a compilation of seat warmer speeches?
Sure.